The human presence in outer space is undergoing a transition from one in which nation-states are the dominant actors to an emerging status quo in which states merely supervise the activities of private entities. Such largely commercial ventures include extracting natural materials from the moon, a celestial body of great cultural and spiritual reverence for some indigenous societies. However, the existing international legal framework governing activities in space focuses on its exploration and use, centered in a Western worldview that attaches to a past history of colonialism and exploitation of people and resources. This presentation examines the historical record for clues about how states, private actors, and indigenous societies might interact in the future on matters of outer space governance to achieve more just ends. It analyzes a key case study, the dispute between the United States government and the Diné people of the American Southwest over the launches of human cremated remains to the moon, acts the Diné president called deeply disturbing and unacceptable to our people. We live in an era of rapidly changing human activities in outer space. The arrival of the so-called New Space Era marked the beginning of a substantial shift in the number and diversity of space actors as commercial entities began to overtake nation-states as the main presence in space. This raises new concerns about the status of existing space law in regard to the rights of people and groups with comparatively little political capital useful in changing policies in their favor. It also questions how the rights of indigenous peoples, in particular, can be guaranteed with respect to the developments on the Earth's nearest neighbor in space, our moon. The history of spaceflight began near the end of the Second World War with the launch of the first human-made objects to reach space. In the 1950s, during the period in which the United States and Soviet Union emerged as the world's superpowers, there was no agreement among nations governing activities in space. After the U.S. announcement in 1960 that it intended to land astronauts on the moon, concerns arose that a territorial claim would follow. These and other considerations led to the process by which the modern international space policy framework was constructed. In 1959, the United Nations established the Office for Outer Space Affairs, an office of the UN Secretariat, to promote peaceful international cooperation in outer space. And it established the Committee on the Peaceful Uses of Outer Space as a representative body to explore legal and diplomatic issues relating to space activities. These entities facilitated the drafting and adoption of the Outer Space Treaty in 1967, among whose provisions is limiting the use of the moon and all other celestial bodies to peaceful purposes. The treaty informs national space policies written by state parties to the treaty, which then descend to detailed regulations and systems by which countries supervise space activities launched from their territories. From the Outer Space Treaty flow a set of 4 further treaties and 5 principles documents. The treaties codify certain aspects of the Outer Space Treaty in more detail, while the principles establish norms of behavior that guide activities in space while not necessarily constituting binding rules. Of these, 3 in particular potentially relate to issues arising between state parties to the Outer Space Treaty and indigenous nations. Of the latter, none are state parties themselves. Consequently, indigenous nations are formally excluded from the UN process to administer the treaty. Their ability to influence space policy decisions stems from the extent to which they can influence domestic and foreign policy decisions made by state parties to the treaty with which they have a governance relationship. 2 historical episodes offer insight into the ways in which the government of a spacefaring nation, the United States, dealt with objections raised by indigenous nations with respect to that government's activities on the moon. These episodes illustrate the complex interplay between the rights of indigenous peoples, their religious freedom, the Outer Space Treaty, and the actions of private commercial entities in space. On 7th January 1998, NASA launched the uncrewed Lunar Prospector spacecraft toward lunar orbit. Its mission was to map the moon's surface composition. After 570 days in orbit, the mission ended when, consistent with NASA planetary protection guidelines for the disposal of spacecraft at the end of their missions, Lunar Prospector was deliberately crashed into a crater near the lunar South Pole. A small polycarbonate capsule aboard the spacecraft contained 1 ounce of the cremated remains of the American planetary scientist Dr. Eugene Shoemaker, who performed groundbreaking scientific research in the 1950s demonstrating that certain geologic features on Earth were the result of the impacts of comets and asteroids on our planet. Shoemaker spent much of his later career searching for previously undiscovered impact craters around the world. In 1997, during one of those trips, Shoemaker was killed in an automobile accident in Australia. Sending his ashes to the moon was the idea of Shoemaker's former student, Carolyn Porco. In 1999, Porco said, quote, "It was legend among planetary scientists that Gene's lifelong dream was to go to the moon and study its geology firsthand. At his journey's end, 30 years to the month after humans first set foot on the moon, Eugene M. Shoemaker will become the first inhabitant of Earth to be sent to rest on another celestial body." Unquote. When word of the planned tribute reached the Diné people of the southwestern U.S., also known as the Navajo, their leaders reacted publicly with dismay and outrage. According to Diné tradition, the moon is not merely a celestial body, but rather a deity deeply rooted in their creation stories and ceremonies. Aversion to the remains of the dead is also culturally significant for the Diné. The action undertaken by NASA was therefore considered offensive on both accounts. NASA faced unwanted media attention for flying Shoemaker's ashes to the moon, much of which focused on the lack of consultation with Native Americans before proceeding with the plan. While it did not rule out the possibility of sending human remains to the moon in the future, it promised a different course of action. Between 1998 and 2021, successive U.S. administrations set forth new executive policies intended to improve relations between Native American nations and the federal government by engaging in coordination and consultation on matters of cultural importance. In a memorandum of understanding issued during the administration of President Joe Biden, 8 major federal agencies agreed to, quote, "work together and consult with Indian tribes and Native Hawaiian organizations in developing and implementing actions to improve the protection of and access to tribal and Native Hawaiian sacred sites," unquote. Yet it also noted that the memorandum was merely voluntary, a non-binding agreement, and not enforceable by any party. As now, there were no legal constraints on launching human remains to the moon from U.S. territory, nor did there exist any requirement that the federal government consult with Native Americans before conducting such activities. By 2023, commercial activities in space dominated over those conducted exclusively by governments. Astrobotic Technology, an American space company, proposed Peregrine Mission 1 as part of NASA's Commercial Lunar Payload Services Initiative, which allows the agencies to outsource the launch and transport of lunar cargo to private companies. NASA paid Astrobotic Technology to carry 5 payloads on the mission, which was otherwise privately funded. If successful, it would have been the first U.S.-built spacecraft to soft land on the moon since 1972. 2 other U.S. space companies, Celestis and Elysium Space, were ride-sharers on Peregrine Mission 1. Both provided what they referred to as lunar burial services, promising clients to deposit small capsules of their loved ones' remains on the moon with prices starting at $13,000. This upset the Diné, particularly because they were not consulted, contrary to NASA's promises made in 1998 and later policy changes intended to address the problem. In December 2023, Navajo Nation President Bu Nygren addressed his people's concerns to NASA and the U.S. Department of Transportation as the regulatory agency responsible for launch clearances via the Federal Aviation Administration. In the letter, Nygren asked the government to delay the launch pending immediate consultations. Nygren wrote, quote, "We believe that both NASA and the U.S. Department of Transportation should have engaged in consultation with us before agreeing to contract with a company that transports human remains to the moon or authorizing a launch carrying such payloads," unquote. Nygren was contacted by NASA Administrator Bill Nelson, who indicated that the agency's commitment to tribal consultation was unchanged. The Biden administration convened a last-minute meeting with Diné leaders and others to discuss the issue. NASA reportedly told tribal representatives at the meeting it didn't have to consult with them because the flight wasn't a NASA mission. A NASA official asserted that, quote, "the approval process doesn't run through NASA for commercial missions," unquote, and therefore the launching companies alone decided what they would launch on the basis of business considerations. Similarly, the Federal Aviation Administration denied responsibility for the contents of the payloads launched into space from U.S. territory, noting that its oversight role is, quote, "statutorily limited to ensuring space flights do not pose a safety or national security threat to the United States," unquote. Celestis and Elysium Space publicly criticized Diné leaders. The CEO of Celestis, Charles Schaefer, said, quote, "We are aware of the concerns expressed by Mr. Nygren, but do not find them substantive," unquote. Schaefer then went on to assail Diné religious freedom. Quote, "Simply put, we do not and never have let religious beliefs dictate humanity's space efforts. There is not and should not be a religious test," unquote. Astrobotic Technology CEO John Thornton complained that the Diné did not raise concerns about its launch earlier, pointing out that it announced the mission as early as 2015. Quote, "I've been disappointed that this conversation came up so late in the game," unquote, Thornton said. Yet Thornton maintained, quote, "We are really trying to do the right thing, and I hope we can find a good path forward with the Navajo Nation," unquote. Over continued tribal objections, Peregrine Mission 1 launched on 8 January 2024. Hours after liftoff, the spacecraft developed a serious fuel leak. It spent 6 days orbiting the Earth while engineers attempted to correct the problem. Realizing it could not land the spacecraft as planned, and in order to ensure it would not become a source of space debris, Astrobotic Technology intentionally deorbited the spacecraft. Peregrine Mission 1 and its cargo of human cremated remains re-entered the Earth's atmosphere over the South Pacific Ocean. Neither Celestis nor Elysium Space reacted publicly, noting only that elements of the mission were considered by them to be a success and that they were committed to attempting future missions. Both incidents took place against the backdrop of repeated broken agreements and treaties between the United States and Native American nations. Through this historical lens, the deposition of human remains on the moon appears to be another event in the ongoing colonization of the Americas. Indigenous people offended by the actions of colonizers find themselves without the legal agency to effectively assert their rights insofar as space activities sanctioned by the United States are concerned. Although the Outer Space Treaty signatories bear responsibility for supervising the actions of launching entities in order to ensure compliance with the treaty, it was framed in such a way as to center a Western capitalist view that considers space an object of human utility subject to exploitation for its benefit. This creates a stark contrast with the frequent indigenous view of a reciprocal relationship between humans and nature. Furthermore, the Outer Space Treaty and its implementation process effectively excludes from meaningful participation indigenous groups that do not possess full legal sovereignty. In the example of Peregrine Mission 1, the Navajo Nation calls for consultation likely did not invoke the relevant provision in Outer Space Treaty Article 9 calling for dual regard, as the matter was considered internal to the United States. However, it is arguable that the Biden administration's actions were at least inconsistent with its stated position with respect to engaging Native nations. The Navajo Nation is ineligible to join or leave the Outer Space Treaty on its own. Rather, it is subject to it because of its quasi-sovereign status as part of the United States. This makes the federal government the representative of the Navajo Nation to the United Nations, but it is not bound to articulate the Diné point of view on any particular matter of space law. With a tribal membership representing only 0.12% of the population of the United States, it is difficult to envision any scenario in which the Diné wield sufficient political power to influence the U.S. position on lunar policy matters through the democratic process. Despite all of this, future approaches to space policy, and in particular policies focusing on human activities on the moon, could be decolonized in part by bringing sovereign indigenous peoples fully into the policymaking process. With this in mind, we conclude with thoughts on appropriate ways to engage indigenous nations in co-creating a human future in space. First, much of that future is preconditioned on a wider recognition of the inherent rights of indigenous peoples, a struggle that continues around the world. Until indigenous nations achieve substantial sovereignty over their own affairs, their participation in space policy discussions cannot be full. Second, meaningful engagement in decision-making must accept indigenous methodologies as distinct and equally valid alongside other ways of knowing. Rejection of inherently decolonizing views denies proper representation to all people. And third, consultation alone does not constitute meaningful engagement with a process. Given the consensus nature of international norms and standards for acceptable actions undertaken in space, including on the moon, anything short of free, prior, and informed consent from indigenous people is inconsistent with the idea enshrined in the Outer Space Treaty that space is, quote, the province of all mankind. Thank you for your attention.